let me state for the record that the committee have required the submission of AMLC records without a court order. And let me reiterate that under the Anti-Money Laundering Act of 2001, suspicious transaction reports and covert transaction reports are confidential and may only be disclosed upon order of a court. The House of Representatives Committee on Justice does not have the authority to direct the AMLC by issuing a legislative subpoena and consequently cannot bypass the probable cause requirement of the court. The report of suspicious transactions are meant to be used by the AMLC for analysis and its own determination of probable cause, where required by the judiciary. That's my manifestation, Madam Chair.
Thank you.
Madam Chair.
The manifestations
Madam Chair.
are noted.
Madam Chair.
Any other member who wishes to
Madam Chair.
manifest or raise
Madam
clarificatory question? The Honorable Diokno and then the Honorable Ko.
Madam Chair.
Just a
Also me.
counter manifestation, Madam Chair.
You may proceed.
We have to emphasize this, that the Bank Secrecy Law itself provides, and I quote, all deposits are hereby considered as of an absolutely confidential nature, just like the AMLA law, except in cases of impeachment. Iba po yung exception sa court order sa exception in cases of impeachment. And I believe that the reason is very clear because we are here speaking of accountability of public officers. If we allow the Bank Secrecy Law to become a tool that will hide key evidence from the Committee on Justice, magiging baliwala po yung impeachment process. This will become an exercise in futility. Hindi natin magagampanan ng ating tungkulin kung nakatakip ang ating mga mata. And that's why to fulfill our duty under the Constitution and to the people, the committee must exercise its power to examine all the evidence, including the records coming from the Anti-Money Laundering Council regarding covered and suspicious transactions linked to Vice President Sara Duterte. Thank you, Madam Chair.
Madam
Chair.
Madam Chair.